When I call your name, along with the number, that's the number that you're gonna have for this process. Okay? And when I call your name and number, you go in and just when you're repeat it. Okay, we have Ms. Newton, you're number one, love, and you're ready to go. Richard Austin.
Ms. Newton, you're gonna sit in that first chair behind that wall, all the way to the end. Richard Austin, Mr. Austin, you'll sit next to Ms. Newton.
Marshall, this one is here.
Mr. Seferati, you'll sit next to Mr. Austin, right over here with the yellow shirt. And Ms. Marshall, you'll sit next to Mr. Seferati.
Born.
Ms. Steincloss, you'll sit next to Ms. Marshall.
Youngblood.
Miss Bourne, Jamie Bourne. There's a seat between you and Miss Steincloss. You're gonna sit right there. Mr. Sadler, you're gonna sit in that first chair. In that second section, and Mr. Youngblood, you'll sit next to Mr. Sadler. Foster, you'll sit next to Mr. Youngblood. Russo, you'll sit next to Mr. Foster. Janice Ryan, there's a seat between you and Miss Russo. Sit right there, yes.
Okay.
DeRanery?
Yep. DeRanery.
DeRanery. You're gonna sit right here on the end, next to Miss Ryan. Rios Ortiz, you're gonna go to that second row of chairs, all the way down to that first chair, that group over there. And Miss, let's see, Hernandez, there's a seat between you and Mr. Rios Ortiz. And Ms. Threes, you're sitting next to Miss Hernandez. Pugh, sitting next to Miss Threes. And Savoy, you'll sit next to Miss Pugh. Good afternoon, ladies and gentlemen. I'd like to welcome you to County Court at Law Number 2. My name is Judge Terrence L. Holmes. I'm the presiding judge here in County Court at Law Number 2. You have been asked to come to court today to serve as a juror or a potential juror in a criminal case. Now, the case that we have in this court is a misdemeanor criminal case. Criminal cases are divided into felonies and misdemeanors. Your felony cases are handled in the district court. Felony cases are normally referred to as your most serious type offenses, whereas your misdemeanor cases are normally referred to as your petty offenses. Does not mean that the misdemeanor cases are not serious. It just means that they are not as serious as a felony case. Now, when I use the term serious, what I'm talking about the facts of the case and the possible punishment that a person can get if they are found guilty of the offense. You will be examined for inclusion on this misdemeanor jury. Now, our courtroom hours vary. Courtroom hours are normally from 9 a.m. in the morning to 5 p.m. in the evening. However, in County Court at Law Number 2 of Jefferson County, Texas, we usually handle other dockets in the morning. For example, this morning we had a jury trial docket, announcement docket, and we had a pretrial conference docket. Now, and so therefore, we have our jury trials in the afternoon. For example, if the cases that were on the jury trial docket was not reached and they were scheduled to go to trial, then we handle those trials at 1:30. And our courtroom hours are normally from 1:30 to 5 p.m. Now, whether you are selected as a juror today in this case, you are performing a significant service which only free people can perform. If selected, this case rather will be tried expeditiously, consistent with justice, which require a careful and impartial trial. If selected on the jury, unless otherwise instructed, you will be permitted to separate yourself for recess, for meals, and at night. Now, at this time, I must administer to you the first of 2 oaths. So I need each and every one of you to raise your right hand, and then once I finish administering the oath, please say, "I do." Do each of you do solemnly swear or affirm that you will make true answers to such questions as may be asked of you by the court or under its directions touching your service and qualifications as jurors, so help you God? Please say, "I do." Okay, you may put your hands down. The law requires that each of you must possess certain qualifications before you may be considered for service as a juror. Also, there are certain excuses and exemptions some of you may wish to claim. First, I would like to determine if all of you possess the qualifications for service on a criminal jury. It is very important that you answer these questions truthfully. If you do not, and the lawyers or I discover this fact after you are seated on a jury, this case could be retried, and you may be held in contempt of court and placed in the county jail for up to 180 days and be given a fine up to $500. Now, the way I'm going to ask the questions is as follows. I'm going to ask a series of questions. I do not want you to answer those questions out aloud. Please answer each question to yourself. And once I finish asking the last question, I will then ask, is anyone disqualified under the law? Now, if you think that you may be disqualified under the law based on your answer to at least one of the questions, then I'm going to ask that you raise your hand, and then we're going to ask that you come before the bench so that we can discuss the matter more privately. Now, when I use the term more privately, I need to inform you that currently we are airing on YouTube. And I will turn the YouTube off. I will turn this microphone off. And then I will turn on a noise sound device that sounds like this. Okay. Now, again, I'm going to ask a series of questions. I do not want you to answer those questions out aloud. Just answer the questions to yourself. And once I finish asking the last question, I will then ask, is anyone disqualified under the law? If you think that you may be disqualified under the law based on your answer to one of the questions, then I will ask that you raise your hand and then we'll ask you to come before the bench so we can discuss the matter more privately. First question. Except for failure to register, are you a qualified voter in Jefferson County and in the state of Texas under the Constitution and laws of the state of Texas? Have you ever been convicted of theft or any felony? Are you under indictment or legal accusation or on deferred adjudication for theft or any felony? Now, before I ask the next question, I need to inform you that I'm required to ask these questions by law, and so I'm not trying to pry into your personal affairs. The next question is as follows. Are you presently insane or have you been declared insane by any mental health or judicial official? Are you 18 years of age or older? Are you a citizen of the United States? Are you a resident of Texas and a resident of Jefferson County, Texas? Are you of sound mind and good moral character? Are you able to read and write the English language? And this is the last question. Have you served as a petty juror for 6 days in the preceding 3 months in a county court or 6 days in the preceding 6 months in a district court? Is anyone disqualified under the law? If you think that you may be, just raise your right hand. Let the record reflect that no one on the panel raised their right hand. Now I will determine if anyone who is otherwise qualified to be a juror wishes to claim one of the following exemptions. You may claim any of the following exemptions if you choose to, but you are not required to claim them. If one of these applies to you, but you still desire to be considered as a juror, just remain seated. Now, I'm going to ask these questions in the same manner that I asked the previous set of questions. That is, I will ask a series of questions. Please do not answer those questions out loud. Just answer the question to yourself. And then once I finish asking the last questions, I'll ask if anyone would like to claim an exemption. Question number 1. Are you over 75 years of age? Do you have legal custody of a child or children under the age of 12, and jury service would necessitate leaving the child or children without adequate supervision? Are you a student in a public or private secondary school? Are you enrolled and in actual attendance at an institution of higher education? Are you an officer or employee of the Senate, the House of Representatives, or any department, commission, board, office, or other agency in the legislative branch of state, government. Have you served as a petty juror in Jefferson County during the past 3 years? Are you the primary caretaker of a person who is an invalid, unable to care for himself or herself? And this is the last question. Are you a member of the United States Military Forces serving on active duty and deployed to a location away from your home station and out of Jefferson County? Is there anyone on the panel who would like to claim an exemption? Let the record reflect that no one on the panel is claiming an exemption. Now I will move to excuses. Now with the excuses, I'm not going to ask any questions. I will make 3 statements, and if based on these 3 statements, if any of these statements apply to your circumstances, and if you like to claim an excuse, then we will have you to come up before the bench so that we can discuss the matter more privately. First statement. A juror may be excused for observance of a religious holiday upon completing an affidavit as required by the Texas Code of Criminal Procedure, Article 29.012C. A juror may not be excused for economic reasons without the consent of the parties, that is, without the consent of the defense and without the consent of the state. Now, this is the last statement. A juror who, without prompting, articulates an inability to listen to testimony and be fair and impartial may be excused. Is there anyone on the panel who would like to claim an excuse? Let the record reflect that no one on the panel is claiming an excuse, no one is claiming an exemptions, and all members of the panel are qualified. State, are you ready?
Yes, Your Honor, state is ready.
Defense, are you ready? Okay. Again, ladies and gentlemen, I'd like to welcome you to County Court at Law Number 2. We just finished impaneling the jury. Now we will do what is called voir dire. Let the record reflect that the court has convened in this case, cause number 24 CCCR 1702, and at 2:30 p.m. on today's date of July 27, 2026, and the case is styled the State of Texas versus Terrence O'Neill. The defendant, counsel for the defendant, counsel for the state, and all members of the jury panel are present. Again, ladies and gentlemen of the jury, you have been summoned to this court as a prospective juror in a criminal case. The defendant is Ms. Terrence O'Neill. She's sitting at counsel table with her attorney Laurie Perazzo. The state is present and represented by Assistant Criminal District Attorneys, Attorney Fred Verner, sitting first chair.
Good afternoon, everyone.
And Attorney Farrah Nixon, who is sitting second chair. The court reporter is sitting to my left is Mr. Sebastian Aguilar. He will be taking down everything being said. So speak up when you are answering or asking questions. The bailiff, Miss Brenda Mosby, you met her earlier. The defendant in this case stands charged by information with the Class A misdemeanor offense of hindering apprehension or prosecution. Now, I'll just explain to you, ladies and gentlemen, in the felony court, a person is charged by indictment. The case has to go before the grand jury, and then the grand jury has to return an indictment. But in misdemeanor court, it's an information. It's just a different in terminology. One is an indictment in felony court. This information in county court. So the defendant stands charged by information with the offense of Class A misdemeanor offense of hindering apprehension or prosecution. The state and the defendant, through their attorneys, have the right to direct questions to each of you concerning your qualifications, background, experiences, and attitudes. In questioning you, they are not trying to meddle into your personal affairs. They're just trying to select impartial jurors to hear and decide this particular case. If at any time you would prefer not to answer certain questions in the presence of the panel, just say so. And I will ask you to come up to the bench so that we can discuss the matter more privately. And again, is the state ready to proceed?
Yes, Your Honor, the state is ready.
And is the defense ready to proceed? Now, Mr. Vernon and Ms. Razzo, is 30 minutes enough for each side?
Yes, sir.
Yes, Your Honor.
Okay, and I'll keep time. Mr. Vernon, the panel is yours.
Yes, Your Honor.
You're welcome.
Good afternoon, everyone. Hope everyone's Monday is off to a great start. Once again, my name is Chris Vernon, and I am a prosecutor. And in this courtroom, myself, as well as my colleague, Mr. Nixon, we are going to represent the state. We also represent the community. Additionally, I'd like to formally welcome you on behalf of myself, Mr. Nixon, and I'd like to welcome you to County Court Law number 2, as the judge has stated earlier. And welcome to Board Doc. So what is Board Doc? Well, it's kind of like the first date. All right. So I'm going to talk to you a little bit, get to know you. Except you can't leave. You're under oath. Nobody gets to say it. except for maybe 6 or 7 people that will be fortunate enough to be on the jury panel. In such case, I look forward to getting to know you all. But seriously, what is voir dire? Voir dire is a French word that means to speak the truth. It means to speak the truth. So today, I'm going to visit with you all, and I'm going to tell you some truthful things about myself so that so that you all get to know me. And then in exchange, I'm going to ask you all to tell me some things about yourself and speak the truth to me so that I can get to know you as well. Now, I want this environment conversation to be very informal. So if at any time you have a question, simply raise your hand, and you may call me by my first name. And is it okay if I refer to each of you by your first name as well? Okay, thank you. How does voir dire work? It's a jury selection or jury deselection. So each side, both the state and the defense, can make 3 releases or strikes, as they call it. I like to call them a release. Okay. And then what will happen is, after we make our releases, the top number starting from number 1, the remaining folks will then be the remaining 7 folks will be allowed to sit there in the jury panel with 1 alternative. So 6 jury members of the top numbers remaining and then one alternative. Now, why do we need a jury system to find someone guilty or innocent? Couldn't the judge just do it? Couldn't Mr. Andrew do it? Couldn't the Bailey do it? Well, the founding fathers of this country all agreed that that is too much power for one person to have. And so one person should not be allowed to say, oh, you're guilty or you're innocent. So what they did was they engrafted it into the Constitution that a person can only be found guilty if a jury pool or jury collective or a jury team, as I like to call it, comes together and says, hey, what you did was wrong under the terms of the law. So now in our Constitution, and down here at Boyd Dyer, we're going to select that jury team, that group of individuals that are going to work together to determine whether the defendant is guilty as charged of the crime. Now, she has the presumption of innocence, but again, it'll be up to the jury team to determine whether she is guilty. So you can say that the law empowers you all. It entrusts you all with the responsibility of determining whether justice will be found. It entrusts you all with the responsibility to protect our community. It is important that we all take it seriously. Now, who here has been in a team dynamic, either at work or played sports? Who in here has played on a team or where you had to work together with a group of people? Okay, and you are Miss Jamie. Tell us about your experience in the team.
Sports. Do you want to?
Which sport did you play?
I played softball and volleyball, basketball, in kids school.
Who'd you play for? Or ancient growth, how was your experience there?
Amazing.
Okay, okay. And which position?
Shortstop.
Okay.
Short girl on the basketball team.
That's all right. You still played nonetheless. That's what matters. Anybody else here? I saw some hands up. Yes, sir. You played any sports or you worked in a field where you have to work together with people?
But
Okay, let's talk about sports.
which ones?
What sports did you play?
I played many sports,
Mhm.
high school and college.
Okay, football, basketball,
Football,
Football.
baseball,
which position in football?
quarterback.
Quarterback. All right, all right. Were you pretty good?
That's okay.
All right, all right. Let me ask you this. You had an arm like Tom Brady, okay? And you are Mr. Paul, or I'm sorry, Larry.
Yes.
Okay, Mr. Larry, if you had an arm like Tom Brady, okay, you're playing football, you're down there, it's Friday night, you're under the lights, you're in the center, you're taking that snap. And you got some decent receivers, but they're not so good, your offensive line ain't that good. And you drop back to pass, but you got an arm like Tom Brady, but the other team's really good too. Can you, on your own, win that football game?
No,
Why not?
gotta have a thing.
Gotta have a team. So it doesn't matter how good your arm is, if your receivers ain't working, and you throw that ball perfect spiral, it's gonna happen.
Correct.
Yes, sir. They ain't not gonna catch that ball, no matter how good you throw it. It takes the team to win. Someone on the back row, anybody sports, team, football work? Yes, sir.
Football official,
Football official?
yeah,
Okay,
crew, I had my own crew,
okay. Yes, sir.
you know, been doing it for 40 years,
40 years.
yeah, oh,
And my dad always tells me, I tell him getting older, I tell him, it always beats the alternative.
I'm not sure about that sometimes.
Yes, sir. Yes, sir. And John is your name?
Yeah.
Okay, so you got a crew of referees that you kind of oversee? And
Sure.
do you also call balls and strikes when you're the referee for those games?
We don't have balls and strikes in football.
All right, we do not. I like that. I'm biased. I'm biased.
But no, I call, I'm a referee. I take care of what's my responsibility, and I expect my guy to take care of theirs responsibility.
Yes,
There's no way one person can call a football game.
yes, sir. But you can't see everything that's going on all sides of the field at the same time.
Coaches tell me I can.
Sir?
Coaches tell me I can.
Yes, sir. Yes, sir. But it does in fact take a team. All right. Anybody else in the back row? Work, yes, ma'am.
been a volunteer coach for the YMCA
Mhm.
for volleyball team for growth for about 2 years now.
Mhm.
And then I work in the community and just try to build partnerships and collaboration for the community training.
Well, thank you for that, your contribution. Is Yadira? All right, Ms. Yadira, why is it important that in collaboration and working across different networks, and what happens if there's miscommunication or people aren't working together? Can you accomplish the goal?
No.
Why not?
Because you need collaboration and partnerships to get to, in my case, the resources to help the community. So without one person.
Yeah, thank you. So the truth of the matter is that being a part of a jury is just like being part of a team. People working together. Now I noticed when I was looking at the jury sheet, we have accountants, anybody, construction here, working construction or engineering? Yes, sir.
What kind of construction? A scaffold builder?
Scaffold builder.
Yes.
Okay, that team dynamic is important, right? What happens if the team doesn't work together in scaffold building?
Yeah.
What happens if somebody doesn't do their job, but you get everything right, but one person doesn't do their job?
It can create huge accidents, even causing fatalities as well.
Yes, sir, cause a fatality, that's right. And so Jamie,
Yes.
yes, sir, we can cause a fatality. And so here, if the team doesn't work together to find justice, guilty people get let go. Okay, community is less safe. All right. Now, who agrees with this statement here? Being a jury member is sort of like being a part of a team. Who here agrees with that statement? Who here disagrees with that statement? I have to ask, Mr. Paul. I didn't see your hand go, what do you agree? Okay, so we can agree that being part of a jury, part of that six is part of, it's like being the truth? Okay. Thank you. Anybody disagree? Speak the truth to me. Okay, thank you. So if being on part of a jury team is like, if being a team working together, what's my role? The next logical question. Well, let me tell you a little bit about myself, and I'll tell you a little bit about my coaching style. So I'm kind of like John, all right, in this Yajira. My role here is to be a coach. My role here is to provide each and every one of you with the resources necessary to make a finding beyond a reasonable doubt. Beyond a reasonable doubt, and we'll define that term here shortly. But my job is to get up here and get you the evidence that you need to feel comfortable about making a decision and finding justice. Okay? And my style as an individual, because I am the son of a mother who's a teacher and the son of a father who's a Baptist pastor. Some of you may be able to tell that in my voice, but my style is very direct, straightforward, straight to the point. Okay? I don't come here to play games. I come here to get to the truth. And I ask that when I show you the truth, I ask that you stand on it. Stand firm in your conviction. Stand firm with your gut. Stand firm with your instincts. Stand firm with your experience. And you go straight forward. And you get back there, some of you go in that deliberation room, and you find the defendant guilty. Because I'm going to do my job as a coach and give you everything that you need to protect this community. And so with that, I'm going to make 4 promises to you right now. I'll raise my right hand to God. I will never lie to you. I will tell you the truth. I will never put anybody on that there stand that I'm not personally convinced is going to tell you the truth. And if somebody takes that stand, number 3, if someone takes that stand, anyone takes that stand, and they attempt to shade the truth, I will draw it out and I will expose it for you. And you'll see me, I'll look at you, I have a long pause. I can't be like, hey, they're lying, but I can look at you and you will know. Someone gets up there and shades the truth, I will expose it to you. Okay? Now, what's the judge's role in all of this? Well, we know now the Constitution says judge is not the king. The judge is here to call balls and strikes under the rules of the law. So sometimes y'all may step out a little bit, we'll have a sidebar, the defense out, we'll argue about some things, and then he'll ask you to come back in, okay? So, the judge, y'all hear him, gonna call balls and strikes. You know, say objections, get an objection, it's gonna be overruled or sustained, okay? Overrule means, hey, whatever the person did, okay, sustained, okay, that's, you know, that was okay, all right? So, why do we have rules of sports in England? Why do we have rules in sports? Sports in our rules, why do we have balls? Anybody care to volunteer?
Have a game without them.
Can't have a game without, yes, sir. What's it? Miss Daniel? Why do we have rules and laws in our rules?
To, encourage people to do.
Yes, ma'am. What's it? They encourage people to do the right thing. Laws are there to keep us safe. Laws are there to make sure that balls are balls and strikes are strikes, so touchdowns are touchdowns. The facts are facts. So who's the one to talk to me about what happens on your job if you don't follow the rules? Ms. James? What do you do for work? If you don't mind.
I'm retired,
I'm
and
sorry.
I was the school teacher for 30 years,
Okay. Where did you teach?
for Natchez Crest High School.
Did you enjoy it?
Yes, I also taught at West Crest.
Okay, okay. Thank you for your contribution. Again. Now, I want to ask you a question. What happens if you set up rules in your classroom and a student decides they're not gonna follow the rules? What happens if what happens if you want powerful?
Lose control of the classroom. It's chaos.
Yes, ma'am. So those rules kind of help keep the classroom together? Yes, ma'am. Yes, ma'am. Now, is there anybody here who thinks we shouldn't have rules? Is there anybody here who believes that, rules are meant to be broken? So we all agree rules are meant to be followed. Okay. Now we're gonna get more specific, and at this point, I'm gonna ask you to speak the truth to me. Does anybody here know what a search warrant is? Yes, sir?
Yes,
Okay, what is a search warrant?
it's, court right for the police and other law enforcement to enter a premise and find out,
Yes, sir, that's correct. They go in there and you go search, they get the law, authorize them to go and search for something. They go and find something. Why do search warrants exist? Why are they important? Anyone care to volunteer? Miss Letitia? Why are search warrants? You're being too quiet over there. I can't talk to you. Why are search warrants important?
Search warrants are important to collect evidence. In times of men, I think. Men.
That's been answered. Could get to collect evidence in a timely manner. And, is it Carrie? Yes, sir, Mr. Carey. Why are, search warrants, important to you? Why do you think they're important?
I think like she said, it is important to collect everything in our cases. To bring it out. That way the courts or people else will correct, show what's going on.
Yes, sir. And so I'm gonna explain a little more about that. So a search warrant has to be signed off by a judge and it has to be sworn to by the person who's providing the probable cause affidavit who says that, hey, there's something wrong here. And judge, I need to go search, okay? And the judge has to sign off, okay? And it has to be probable cause. Okay? Now, if the police officer has a search warrant, should they be allowed to search whatever it is they're particularly search? Should they be allowed to get there? Should they be able to do that without interference? Yes?
Yes.
Okay,
it depends.
okay, talk to me, it depends on what.
It's a case up in, Austin, cops and police knocked cold down, middle of the night, had a search warrant. They did it all so fast, a young man in a bed, he don't know nothing.
Mhm.
He sees a plainclothes officer come to the door and they get a gunfight. One of them dead, one of them. And police cannot just take a search warrant. I not bang, kick the door in and go in.
Mhm.
They have to have reasonable time frame for people to react. The purpose of the search warrant is to put the brakes on government. It's not to allow them to go in, make them have to follow a set procedure and as you said, probable cause. And served in a manner that doesn't take it to lethal force. Just going in to get something because someone, forgot to pay their fee.
Let's talk about that.
There's a lot of things that come with a search warrant.
Yes, sir.
Police have been known to lie. Case up in, Trinidad,
Mhm.
police chief went to the judge. Got this lady talking bad on, Facebook. She said terrible things. It's gonna scare people. He signed off the warrant.
Mhm.
Come to find out, it didn't happen, and he told the police now, you have to come in person. So what I'm saying is there are a lot of things that go into a search warrant.
Yes, sir, and there are, such as probable cause, okay, judge signature, officer signature, sworn affidavit. So let me ask you this, if the police have all of those things, okay, because the search warrant does protect our rights. We have rights under the Constitution, okay, that's why you have to get a warrant. But let's say they've got the warrant, and they come to you, and they want some, do you think it's okay to hide things from the police if they've got a warrant to search them?
They've got the warrant to file probably, doing things that will put someone in fear of their life so much that they react to get away. Yes, they should be allowed. I don't believe that the police stop and they should come in and be able to search for what the warrant says they can search.
Okay, so let me ask you all this. Who else, is there anybody here that feels that if the police have a warrant and that warrant says, hey, you come here, you can search this area, who believes that you should be able to tell the police no? Does anybody here believe you should be able to tell the police no if they've got a warrant? Is there anybody here that believes that I should be able to hide something? If the police have a warrant, I should be able to cover it up in my jacket? And I walk away, toss it in the trash can. Is there anyone who feels that's okay? Speak the truth to me. Speak the truth to me. Yes, sir.
I think you would have the right to say no,
Mm-hmm.
because, I mean, I know they have a warrant and I know it's signed by a judge, but you still would have a legal right to say no, even though you may not get it done that way, but you would still have a legal right, I think.
Fair enough. Is there anybody here who feels like Mr. Carey? Anybody here feels like Mr. Carey?
Kind of do,
Okay.
because you can't trust people. not-
Your Honor, I'm sorry, I'm gonna have to make an objection to this line of questioning. It's irrelevant because there was no search warrant involved in this case.
I'm allowed to ask questions.
It doesn't apply, it's irrelevant.
I'm trying to, Your Honor, I'm asking questions. There's no relevancy in a court hour hearing, and I'm allowed to stay away from the facts of the case and ask questions to draw out bias or prejudice, and I'm simply doing that.
You say you're trying to draw a bias or prejudice.
I draw out and understand the jury's feelings and opinions on things. I'm not getting into, I'm trying to stay away from the facts of the case, which I'm not allowed to do. But this line of question is literally has nothing to do with specific facts of this case, so I'm allowed to ask that one question.
Objection sustained. You have 9 more minutes.
So we're going to jump into, I promised to all talk about beyond a reasonable doubt. And what does that mean? Well, the law doesn't define beyond a reasonable doubt, okay? But what it does do is it allows me an opportunity to explain to you what it looks like and what it feels like, okay? So what does beyond a reasonable doubt look like? It looks like a staircase. And down here at the lowest level, we have a reasonable suspicion. Okay, that's the level where someone can pull a vehicle over and make a traffic stop. Next, you have what's called probable cause. That's the amount of certainty that a police officer needs to arrest. Okay, at the next level, you have what we call a preponderance of evidence, which is about 50-50, okay? Then we have clear and convincing evidence. And lastly, we have beyond a reasonable doubt. The only thing above beyond reasonable doubt is no doubt at all. Okay, so that's what it looks like, a staircase. And I'm gonna climb that staircase for you, and we're gonna gladly bear our burden and prove to you beyond a reasonable doubt the facts of this case. Next, what does it feel like? We make choices beyond a reasonable doubt every single day of our life. We hop in our car, we drive through a four-way intersection, and we drive through because we believe beyond a reasonable doubt that it's safe, and we have a green light. Okay? We don't know that the other cars won't run through their red light, right? But we feel it in here, it's green, I've experienced it before, I can drive through that green light and I can do it beyond a reasonable doubt. That's what it feels like. Now, circumstantial evidence. As you're driving through that green light there at that four-way intersection, you can't see those red lights. You can't see if those lights are red. But you know that the cars on the other side, on the opposite lanes, they're stopped. And they must be stopped for a reason. So you can't see that red light, it must be red. And inference, you can infer that it's red because they're stopped. And you go through and you drive through safely beyond a reasonable doubt. Comfortable. Knowing that, yes, someone could run through that red light, but you're comfortable because you've done it time and time again. And I'm gonna ask you to rely on your guts, your instincts, and your experience. When I put someone on that stand, I provide you with evidence. You will be able to know beyond a reasonable doubt that what I'm trying to prove to you is the truth. Now, what is the elements of the offense in this case? I agree with section 38.05, hindering apprehension or prosecution. The person commits an offense if the person conceals, harbors a criminal with the intent to hinder arrest of that particular person. Okay. Now, what does it mean to harbor someone? What does it mean to harbor? What does it mean to harbor? I'm gonna have to call a volunteer, call someone here. Ms. Jane?
To have them.
Hi.
To keep them safe in some situations.
Correct, correct. So, why is it wrong or against the law to harbor someone, a criminal? Why is it against the law? Why should that be against the law? Ms. Carey?
Right, what is the question?
Why should it be against the law for someone to harbor a criminal or conceal a criminal?
There's still the community, but they can be dangerous to the community.
Yes, ma'am, it could be dangerous to the community. Laws are here, rules are here to protect it, and that laws are here to protect our community. So, I'm gonna make one last commitment, and then I'm gonna sit down. I promise you all that by the time this trial is done over the next 2 to 3 days, I will give you evidence, I will give you the law, I will give you the facts, every single thing that you need to drive comfortably through the green light and find justice together as a jury team, as the Constitution requires of you, as the Constitution demands from you. I'm going to give you everything you need to drive safely through the green light and find the defendant guilty. Okay? You can count on that. And I'm going to ask you one other question here. Does anyone know anyone in this courtroom? Any personal relationship? Okay. Ma'am? Who do you know here?
I'm no judge.
Judge Holmes? Okay. Is that gonna affect your ability to be fair and impartial? Or if you put on that jury, can you still be fair and impartial? Would your relationship interfere with that ability? Okay. Very good. Anyone here served on a jury? Oh, yes, ma'am.
She represented my grandson.
Okay, Ms. Laurie? Okay. Feel like you did it. Okay, job.
We don't have to go with more.
But can you be fair? All right. Okay, okay, anyone here served on a jury before? Ooh, quite a bit. All right, we're gonna do this real quick. I got 2 minutes left. Was it a criminal or civil? And criminal, guilty or guilty, okay?
Criminal home jury.
Okay. Okay. And what was the outcome?
The civil was guilty, criminal, halfway through the trial, they gave up and accepted the plea.
Okay.
I'm not sure if that's considered guilty or not.
Yes, sir, that's good. No? No? Criminal guilty, and you are Ms. Camille? Alright. And then,
So similar, it was a workers' comp situation. And we filed in resident.
Mr. Let's see, Michael?
Yes, criminal guilty.
Okay, and Paul, did you review, Mr. Larry?
Criminal, civil, criminal.
And you're on your criminal cases, guilty or not guilty?
One was guilty, one was not guilty.
Okay. No, criminal,
Roles missing second day because they.
thank you so much. And, Mr. Daniel? Any trial, if there's drug report?
No.
Okay. Now, Mr. Jerry?
Attorney General.
Okay. And, now, Ms. Deborah?
Yes, civil lawsuit years ago. They, like, one filed a lawsuit.
And Ms. Letitia?
So,
Okay. And how did it turn out?
of course, we got some, and then we, other. Criminal ways, yeah.
And Mr. Carey?
Criminal and one civil,
Okay.
all guilty.
All right, very good. Ladies and gentlemen, thank you so much for your time. I've enjoyed getting to know you all. I look forward to seeing the magnificent seven very soon.
Ms. Barrasso? You may proceed.
Good afternoon, everybody. I like to use the podium. I need something to lean on. So, my name's Lori Carrazzo. I'm a criminal defense attorney. I've been doing this for about 18 years now. I've practiced here in Beaumont, always have, since the very beginning. I wanted to kind of piggyback off of what the prosecutor began with his questioning about team players. You know, it's really important to work as a team in a lot of instances and in a lot of situations. But it's also equally important to be your own person in a situation like this. Reason being is you want to make your decision and base your decision on your own, not the team's. I can't tell you how many times I've told jurors after a case, and some of them have said, you know, that they felt strong-armed into finding someone guilty. That's real. Now, without getting into, you know, too personal of a question or prying too much into your lives, how many people here think that they could be persuaded by the group to decide one way or the other? And just be honest. I mean, are you a passive person? Are you a more aggressive person? I mean, are you more likely to side with the team other than stand on your own 2 feet and make your own decision? Because I really need you to be honest about that. And there's nothing wrong with it. You are who you are. Show of hands, is anybody a passive person that can probably be persuaded? No? Okay. Good. I'm gonna go over some of the elements of the crime that Miss O'Neill was charged with. And intentionally and knowingly. Those are the first elements of the crime, intentionally and knowingly. So I'm gonna start with Miss Newton. What are some examples of an intentional action? Like, how can you tell if somebody is intending on harboring someone? Like, what would you be looking for the state to show you that showed beyond a reasonable doubt that Miss O'Neill intentionally harbored someone accused of a crime?
If they found the person there.
Okay, so present with
Yeah.
the person that's supposed to be harboring or hiding the person accused of the crime. Okay. Mr. Austin? What are some examples besides finding the person there?
I would look towards, were they hidden in the closet,
Okay,
you know? They
but
made an
again,
effort to
present.
put them in a non-habitable place in the house.
Okay, but again, and thank you, because that kind of expounds on what Miss Newton said. But again, present with the person accused of harboring, right? Okay. Anybody have a different answer? By show of hands, is there another example? Miss Bourne, you look like you want to say something.
Well, it's just like, I mean, could it be considered if they asked if he was there and she knows he's 2 doors down? Is that still
That's a
considered?
very good question. And that's something that you'll have to decide as a juror, if you're chosen. I mean, if that is something, how would you look for proof that would, like, what would you consider intentional with regards to that? Like, what kind of proof, what kind of evidence?
I just,
What, wouldn't you have to prove that she knew that he was 2 doors down,
yeah.
right? You have to prove that she knew it. Does anybody disagree with that? Same thing, and knowingly kind of goes along with intentional. You intended, but you also knew that he was 2 doors down, right? Okay. Harboring and concealing. What would conceal mean? Closet, right? Any other example of concealing a person that you can think of that the state would have to prove? That Miss O'Neill was concealing someone,
She was 2 doors down, she said down.
and she's what?
If he was 2 doors down and she sent him down
Oh, she sent him.
before the cops got there.
Okay, thank you. I'm in my 50s, my hearing is not as great as it used to
I'm in
be.
70, my hearing don't like me.
So excuse me. It's not like it used to be. Okay. Now, beyond a reasonable doubt, we've been told, and I say we, attorneys, prosecutors, defense attorneys, we've all been told by the courts, by the United States Supreme Court, by the Texas State Supreme Court, you cannot define what beyond a reasonable doubt is. You can't do that. You're not supposed to give a definition. But what we all do agree on, and when I say we, the state and defense attorneys alike, is that you know it when you see it. You know it. And you're good. You don't have a doubt. Because if you have a reasonable doubt and you're thinking, well, maybe, well, that's not good enough. This is the highest burden to overcome in our country. That Lower level, to clear and convincing, your children can be taken away. This is a higher burden. Your freedom. Life, liberty, and the pursuit of happiness, that goes away. Okay, that's flushed. And so, I'm not gonna waste a whole lot more of your time. Because I know that, I'm probably gonna lose you if I stand up there any longer. But I just ask you to, look for that. Look for that evidence. And just keep an open mind and use your common sense. Because most of the time, that's really what it takes. It's just common sense. And you know if someone's telling the truth, you know if someone's lying. You can tell that most of the time. Sometimes people hide it, but if the evidence comes out to the contrary and it's concrete evidence, then you know. Thank you for your time.
Okay. Okay, ladies and gentlemen, we're gonna ask that you go out into the hallway. Now, we may have to call some of you back in for some follow-up questions. So at this time, everyone on the panel, please stand. Now, you can go out either one of the two doors. Okay? Jefferson County Law Number 2 is back in session. The court is in session in cause number 25 CCCR 1606. Case is styled of State of Texas versus Calvin Wayne Smith Jr. Mr. Smith, is that your full name?
Yes, sir.
Mr. Smith, would you please raise your right hand? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Mr. Smith, you may put your hand down. How are you doing, Mr. Smith?
I'm doing good. How are you doing?
I'm doing fine, thanks for asking. Mr. Smith, you're represented in your case by your attorney, Attorney Marvel Provo. And Ms. Provo, how are you doing?
I'm doing fine,
That's good. State is represented in this case by Attorney Farrah Nixon. And Ms. Nixon, how are you doing?
I'm fine, Your Honor, thank you.
You're welcome. Now, Ms. Provo, do you waive a record in Mr. Smith's case?
We do, Your Honor.
Mr. Smith, I have before me on my computer a document that is titled Information. This information was filed by the Jefferson County District Attorney's Office. In this information, it alleges that you, Calvin Wayne Smith Jr., on or about April 13th of 2025, while you were in Jefferson County, Texas, operating a motor vehicle in a public place, that you committed the Class B misdemeanor offense of driving while intoxicated first. Mr. Smith, do you understand what you have been charged with?
Yes, sir.
And to this charge, how do you plead? Guilty, not guilty, or no contest?
No contact.
Are you pleading no contest freely and voluntarily?
Yes, sir.
And are you pleading no contest because you do not wish to fight or contest the charges? Mr. Smith, I also have before me on my computer tablet a document that is titled Misdemeanor Plea Admonishments. Do you recognize this document?
Yes, sir.
On page 2 of this same document, there are a set of initials on a line next to a box that's checked no look indirect, which means no contest. Do you place your initials on this document?
Yes, sir.
On page 3 of this same document, there's a signature above the line that's titled Defendant. Is this your signature?
Yes, sir.
And on the next document that's titled Trial Court Certification of the Finished Right of Appeal, do you recognize this document?
Yes, sir.
And is this your signature on the line that's titled Defendant?
Yes, sir.
At the top of this document, there are 2 boxes checked. The first box that's checked states that this is a plea bargain case and you have no right of appeal. Do you understand that statement?
Yes, sir.
Second box that's checked states that you're waiving your right to an attorney, which means you're giving up your right to, that you're waiving your right to an appeal, which means you're giving up your right to an appeal. Do you understand that
Yes, sir.
statement? I also have a document on paper that is titled Discovery Certification. Do you recognize this document?
Yes, sir.
Is this your signature on the line that's titled Defendant?
Yes, sir.
Mr. Smith, before you sign and initial these documents, did your attorney go over these documents with you?
Yes, sir.
And did you understand everything that she went over?
Yes, sir.
Is everything in these documents true and correct
Yes, sir.
to the best of your knowledge?
Yes, sir.
Mr. Schmidt, are you a citizen of the United States?
Yes, sir.
State, would you like to offer State's Exhibit number 1?
Seconded, Your Honor.
Any
No,
objections to
no
State's
objection.
Exhibit number 1? No objections. State's Exhibit number 1 will be admitted. And Ms. Pro, you've advised and counseled Mr. Smith. Is there any evidence that he's currently mentally incompetent to stand trial?
No, Your Honor.
And Mr. Smith, your attorney, Ms. Provo, has advised and counseled you. Are you satisfied with her representation?
Yes, sir.
Has she provided full, effective, and competent legal representation?
Yes, sir.
Mr. Smith, I will accept your plea of no contest. I will find that you are mentally competent to stand trial, but will also find that your plea and waivers were freely and voluntarily given. And I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement?
We do, Your Honor.
And what is the agreement?
The essential terms are as follows: 1 year for probation, $500 fine, 40 hours community service, standard DWI first, terms and conditions, interlock to run concurrent with 25 DCCR 1639 and 25 DCCR 1638.
Okay. Mrs. Smith, the state is offering that you serve 1 year deferred adjudicated probation during the 1 year probationary period. You'll be required to pay a fine of $500 plus court costs of $392. You'll be required to pay DWI conviction fine fee of $100. You will not be required to pay you will not be required to pay probation fee in this case because you're paying the probation fee in the felony cases. And you will not be required to pay a urinalysis fee in this case because you're paying it in your felony case. You will be required to pay a reimbursement fee of $15. You will also be required to reimburse Jefferson County Court appointed attorney's fees of $350. You'll also be required to pay DW Education an initial evaluation fee of $125 on the day of bleach. Should a further evaluation be needed, you'll be required to pay an additional $50. Mr. Smith, your total monthly installments, that is the total amount that you will be required to pay each month on this case, is $123 a month. Are you able to pay the $123 a month?
Yes, sir.
You are. You'll also be required to perform 40 hours of community service. You'll be required to install an interlock device on any vehicle that you own or operate. You'll also be required to attend and complete the DW education class, have an alcohol assessment, follow all the conditions of DWI probation, and the state will be, this case will be running concurrent with your felony cases, cause numbers 25DCCR 1638 and cause number 25DCCR 1639. Mr. Smith, do you understand the state's offer?
Yes, sir.
And do you think the state's offer in your case is fair and just?
Yes, sir.
And do you accept the state's offer?
Yes, sir.
Mr. Smith, I'll follow the plea bargaining agreements that you have entered into with the state. Now, Mr. Smith, if you successfully complete this probationary period, this case will be dismissed. It will not result in a conviction on your record, and you may qualify for a non-disclosure. Mr. Smith, do you understand the state's offer?
Yes, sir.
Now, Mr. Smith, I just have one question. I'm looking at your Jefferson County affidavit of injuries, and I notice here it states that you don't have any income. Is it still the same, or has it changed? Or do you have an income? You have a job, or?
Because my social security check, SSI supposed to be coming out soon.
You say supposed to be. Supposed to be and coming in and being in existence is not the same. So you don't have, you haven't received it.
No, sir, not yet.
So what you're saying is that you do not have any income at this time. Okay. Now, Mr. Smith, let me do this here. Okay, so when we ask if you can pay it, we question is whether you can pay it now. And so you're saying that you can't pay it now.
No, sir.
Okay, let me see. Let's see, 502. $71. Okay. Okay, the court is gonna find that you're indigent. Based on the finding of indigency. The fine in this case is $500 for court costs, so $392 comes to a total of $892. And based on the finding of indigency pursuant to Article 42.15 of the Texas Code of Criminal Procedure, the fine of $500 plus court costs of $392 will be, which comes to a total of $892, will be converted to 71 hours of community service. The attorney's fees in this case of $350 will be waived pursuant to Article 46, pursuant to Article 26.05 G-11 of the Texas Code of Criminal Procedure. The reimbursement fee of $15 would also be waived pursuant to Article 102.018 of the Texas Code of Criminal Procedure. You will be required to pay the $100 DWI conviction fine fee. And because you are on felony probation, the probation fee in this case, you will not have to pay that because you're paying it already in your felony cases. You will not have to pay the urinalysis fee because you're also paying that in your felony cases. So your total monthly installments in this case comes out to be $9 a month. Okay? Now you will be required to perform 40 hours of community service in addition to the 71 hours of community service that was converted from fine and court costs, which comes to a total of 111 hours of community service. Do you understand that?
Yes, ma'am.
You'll also be required to, as mentioned to you earlier, install an interlock device on your vehicle that you're on operate, attend and complete a DWI education class. You're required to pay the DWI education and initial evaluation fee of $125 on the day of the plea. Should a further evaluation be needed, you'll be required to pay an additional $50. You will also require to have an alcohol assessment. This case will run concurrent with the felony cause number 25 DCCR 1638 and cause number 25 DCCR 1639. And you're also required to follow all the terms and conditions of this probation. Do you understand?
Yes, sir.
Okay, now, Mr. Smith, you're going to have a seat in that first chair on the wall. Wait for your name to be called by the court coordinator or the court administrator. Once your name is called, you're going to follow the directions of the bailiff. And once you finish following the directions of the bailiff, you'll be free to go. And you have a blessed day.
Yes, sir.
Okay? And what are we doing on Mr. Oh, here we go. Okay, this is cause number 25 CCCR 2152. Case of style of state of Texas versus Trevor Joseph Stratton. And Mr. Stratton, that's your full name?
Yes, sir.
Okay, now, Mr. Stratton, I have before me in cause number 25 CCCR 2152. You're represented in your case by your attorney Marvel Provo. And Mr. Stratton, I have before me, well, the state is making an oral motion. Is that correct?
Make an oral motion for, bond hearing, bond conditioner hearing.
Okay, you making an oral motion for a bond condition hearing? Okay, now, Mr. Stratton, on October 21st, 2025, the court gave you some bond conditions, is that correct? And I'll just read these bond conditions to you. It states that following return of criminal information in County Court Law Number 2, all bail bonds executed for release of any defendant named herein are ordered subject to the additional conditions. Number 1, the defendant shall commit no offense against the laws of this state, any other state, or of the United States. Condition number 2, the defendant shall not submit to testing for drugs and alcohol at any time as directed by the court. The court may revoke the bond and order the arrest of any defendant who A, refuses to submit to a test for drugs and alcohol when directed to do so by the court, or B, submit to a test of drugs and alcohol, and the test indicates the presence of drugs or alcohol in the defendant's body. And condition number 3, the defendant shall not communicate either directly or indirectly with the alleged victim of the pending offense, and the defendant shall not go near any residence, school, or other location frequented by the alleged victim. Condition number 4 only applies in the DWI case. Your case is not a DWI case. Your case is assault causing bodily injury to a family member. And condition number 5 states, defendant is prohibited from possessing a firearm or ammunition unless defendant is a peace officer as defined by section 1.07 of the Penal Code, actively engaged in employment as a sworn full-time paid employee of a state agency or political subdivision. And condition number 7, the defendant shall wear a global positioning monitoring system device at the defendant's expense, with written verification being submitted to the court within 3 days. And that was effective October 21st, 2025. And it was signed by Judge Terrence L. Holmes on that particular day. Let's see. Affidavit. Correspondence. Motion to modify bond condition. Apartment of Council. Okay. State, are you ready to proceed?
Yes, Your Honor.
Defense, are you ready to proceed?
Yes, Your Honor.
Okay, Ms. Nixon, you may proceed.
Okay, so the state's addressing violation number, no contact bond condition number 3. State calls William Stratton.
Oh. Yeah. Oh, how you doing? Mr. William Stratton, would you please raise your right hand? Mr. Stratton, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Mr. Stratton, you may put your hand down. How are you doing, Mr. Stratton?
All right.
That's good. Now, Mr.
This courtroom, where you at?
Yeah, I know what you mean. Now, Mr. Stratton, the prosecutor would like to ask you some questions.
Good afternoon, Mr. Stratton. Could you identify yourself for court?
William Stratton.
Okay. And what relationship do you have with the defendant, Trevor Stratton?
Father.
Okay, and what relationship do you have with the complaining witness, Cody Stratton?
It's fine.
Okay. Do you know where they live?
They both live with me,
Okay, and where is that?
in Hampshire.
Okay, and how long have they lived at the same residence since October 21st, 2025?
Both of them hadn't been there.
How long have they lived there since that together?
I mean, I don't know exact dates, but he was gone for a while.
I mean, like, since October 21st, 2025, since the bond conditions.
He had just come back home.
Don't know, like when I had.
Hello, sir.
Approximate
She's
what?
testifying.
Man,
What would be approximate date?
I couldn't even tell you, man, to be honest.
But they have existed and they have lived in the same residence
Yeah.
sometime since.
Yeah, cause he was gone, I let him stay at my other little house, camp house, I got on the bayou. And I think his brother signed some kind of letter, he could come back home.
Okay, so they have been in the same residence.
Yeah.
Okay.
Cause he wrote some kind of letter and he got to come back home.
Was there a bond changing these bond conditions?
Well, they called me when it's time to go to court. But
Absolutely.
Mr. Stratton. Who wrote, you received communication from which son? Cody or
communication with
the letter you said?
oh, I think Cody had wrote some kind of letter where he could come back home.
Okay. Do you know if Cody had presented that or to the state? In the board?
I'm not sure, but to be honest.
Okay, and you didn't question anything about Cody presenting it?
Yeah, I mean, they both my kids, they welcome at my house, you know what I'm saying? Mm.
Fast forward.
But like I said, I mean, I know it ain't the trial, but it ain't his fault, man. I mean,
No more questions for this witness.
Okay,
Yes,
you have some more?
Oh,
Okay.
sorry.
Mr. Stratton, were you familiar with the bond conditions? That your son Trevor was on?
yeah, first, just, they didn't want him over there, and like I said, he went to my other house I have on the bayou. And then supposedly Cody wrote a letter where he could come back home. Well, so.
That's all.
Okay. So, Mr. Stratton, are you aware that Cody writing a letter does not change the bond conditions? There actually has to be a bond hearing to change bond conditions.
If we didn't know that, we thought he was like able to go.
Okay.
One day they get along, one day they don't. This is the way brothers do sometimes, you know.
Okay. No more questions.
Okay. You have any more questions? Okay,
Sorry.
Mr. Stratton, you could be seated.
Okay, thank you, buddy.
Mr. Cody Stratton. I mean, the dad can be seated.
Okay.
I know both of y'all last name Stratton. Okay, Ms. Nixon.
Your Honor, for the safety of the community and the complaining witness in this case, the state moves to revoke the defendant's bond for violation of condition number 3.
Okay, and you have any argument? Is that your argument?
Yes, for the violation that they live in the same.
I think my
Residence.
dad misinterpreted.
Well, I mean, that's up
I would like
to your attorney.
I'd like to call Trevor Stratton to the stand.
Okay, you like to call who?
Trevor.
Trevor Stratton.
Yes, sir.
Okay, Mr. Stratton, you gotta raise your right hand. Now, Mr. Stratton, you need to take the gum out your mouth if you have gum in your mouth. Okay, there's a trash can. Where's the trash can?
I got it in my pocket, so it's fine.
Okay, Mr. Stratton, would you please raise your right hand? Do you swear affirm to tell the truth, the whole truth, and nothing but the truth?
Yes, sir.
So help you God. Now, this is your testimony is will be limited to the purposes of this hearing. Okay,
Sir.
all right, Ms. Provo, you may go forward.
You heard testimony from your father in regard to a communication or a letter that was given to him by his brother.
I turned it in to you, I believe. With the one that my dad gave you as well.
Oh, you talking about that letter?
Mm-hmm.
And that's what he went on to.
It was a miscommunication.
And then, like I said, my dad has two houses. I'm not staying at the same house with my brother.
So you're not residing?
No.
Resident?
No, I
You live-
stay at his second house, like you just said.
He just said that he's the brother though. He's a miscommunication.
Okay, so you, are you staying there now?
Yes,
At the house or at the bar?
at the bayou,
Okay,
where my brother lives.
okay, so you have not been in that residence since October of last year, when the bond condition?
Unless I go check the mail over there. Or my mail gets delivered.
Okay. I have no further questions.
Ms. Nixon,
Mr. Stratton? Did you not have, contact with your brother on the July 10th, 2026? So you weren't at your father's home? Your brother was there on July 10th, 2026?
I believe so.
And if the court later finds out that that contact did occur, you're sticking with that story? Okay. You realize you're under oath? So you're saying that you have not been in the same residence with your brother since October of 2025?
Nope.
Okay. And you're saying that in contrary to your father's testimony, where you said y'all are both welcome, and that y'all have shared a residence?
That's what he's always said, we're both welcome to share residence, but I gotta follow what Mr. Holmes said.
But he said that
in my
y'all
bond
did share,
stipulations.
that he testified that pursuant to the letter that your brother submitted to us, that he thought you were allowed to come home and that you were,
Exactly.
that
He
you
thought
shared a
I was
residence.
allowed to come home.
And
But
you
I'm
shared a
not-
residence.
I'm not doing that, because I know that's not court ordered.
But that's what your
That's
father
what he
testified to.
said.
Yes, your father is a witness that was called.
For the first time that happened.
Your father just said that since that your bond conditions were given to you, that y'all shared a residence because he thought that you could because of the letter.
I'm not shared a residence with my brother. Like I stay on Hildebrand, on the bayou.
Your Honor, Mr. Stratton is countering the testimony given under oath by his father.
Not countering, I'm just saying.
William Stratton.
I'm saying, I think my dad slipped up, saying that I was staying at his house, not the King's house.
okay, nobody's asking questions, so you have to wait to speak after someone asks you a question.
Yes, sir.
Okay. Okay,
So,
I think the state,
No,
you still have him on
no more questions.
cross. Okay,
okay,
you may go proceed.
do you think so you presently, you live on the land of your fathers, right?
Yes, he owns two pieces of land, one on Hildebrand over there by the cow store and one in New Hampshire. My brother even say.
Okay, and you have been living at that residence since October 7th of 25?
After I got out of immunity, I went back there.
Okay, and you also telling the court that your brother wrote a letter.
And I gave it to you with the letter that my dad wrote, and we gave it to Mr. Holmes that day.
You gave it to me.
No, she gave it to you that day, sir.
She gave me a letter?
She gave it to me.
No, I gave it to you.
Nobody gave me a letter. Well, I mean, if you're gonna make a statement, make sure you know what you're saying.
My statement, it was a statement from my brother and a statement from my dad.
No, I'm talking about if you say if somebody gave me something,
Sorry.
okay.
So what you're telling the judge, he misunderstood what you off my mind. Okay. But it, but that, letter, to the best of your knowledge, that letter was transmitted to the DA's office, is that correct?
What
To the best of your knowledge,
what was transmitted?
was given to the, DA's office in regard to your brother? Letter.
Oh, yeah, I brought the letter to him.
Mhm. Brought the letter, I presented, that's okay, this way.
I don't understand.
Okay. So basically, it was your understanding that it was okay for you and your brother to stay on the same property of the farm?
No, I just said no 100 times.
No, he stayed, listen to my.
Oh, yeah, on the letter, yes. He wanted me to come back home so he could help redoing the house and all this other stuff, but I feel like it was a trap. I wasn't going back home until this was over with.
Okay, no further questions.
Ms. Nixon,
Yes,
you have any more questions?
no more questions, John.
Okay, you may, okay. And state? You have an argument?
Just for the safety and the safety of the community and for the complaining witness in this case, we wanted to revoke his bond for violating bond condition number 3, given testimony by his father that they were sharing a residence since his bond conditions were put in place.
And Ms. Provo, you have an argument?
I believe that the, motion on, forfeiting his bond based on a violation condition has not been proven, effectively with sufficient proof to, have you, revoke his bond or to raise his bond based on a allegation that they live on the same property as a bond, and that it was, in violation of the bond condition and them not occupying the same residence or the same residence, but not the property.
Okay. That's it?
Yes.
This is me, I'm gonna take this matter under advisement, make a ruling after we finish with the jury selection. Okay, y'all can just have a seat back in the back of the courtroom. When the panel come in, everyone please stand. Everyone please stand. Y'all can be seated. Jefferson County Court Law number 2 is back in session. The court is in session and calls number 24 CCCR 1702. Case is styled the state of Texas versus Tyrannisha O'Neill. Let the record reflect that Ms. O'Neill is present in court with her attorney. Attorney Laura Ferrazzo, the state is present with assistant criminal district attorneys, Attorney Fred Werner, and Attorney Farrah Nixon. Ladies and gentlemen of the panel, when I call your name, please go have a seat in the jury box. There are some badges that are on the countertop. You can take a badge and pin it to your clothing. Dana Newton. John C. Ferretti. Camille Steincross. Michael Sadler. Paul Youngblood. Larry Forster. Evelina Derenary. Okay. She At this time, ladies and gentlemen of the jury, I must administer to you the second of the 2 oaths. Okay. Okay, ladies and gentlemen of the jury, I must administer to you the second of the two oaths. Would you please raise your right hand? And once I finish administering the oath, please say I do. Do you and each of you do solemnly swear that in the case of the state of Texas versus Terrence O'Neill, you will a true verdict render according to the law and the evidence, so help you God? Please say I do.
I do.
Okay, you may put your hands down. Members of the jury, I will give you some instructions and a general idea of what to expect in this case. Every case is composed of facts and the law as it applies to the particular case. The facts come from the witnesses on the witness stand. The law comes from the statutes, codes, rules, and court decisions interpreting them and how they may apply to this case. You and I have equal authority, but it is divided authority. You are the sole judges of the facts, and I'm the sole judge of the law. You are the sole judges of the credibility of the witnesses and the weight to be given their testimony. You can believe all of what a witness says, part of what a witness says, or none of what a witness says. As the trial progresses, the attorneys will probably make objections to questions asked by the other attorney or witnesses, or objections to the introduction of documents or objects. This means that in the objecting attorney's opinion, there's a legal reason why the testimony or document or object should not be received by you. Sometimes I will simply sustain or overrule the objection. At other times, it may require a lengthy discussion outside of your presence. If that happens, I will either ask you to step outside for a few minutes or ask the attorneys to come up to the bench so that you can hear the discussion on the point of law. The reason for this, as I told you earlier, you're the sole judges of the facts you receive, and I'm the sole judge of the law. I can't be with you in the jury room when you deliberate the facts. Therefore, you can't be present or within hearing when I deliberate questions of law. The reason why I will sometimes ask you to step outside is because it is simply the most efficient way to do it. Otherwise, if we were to leave the courtroom, the court reporter would have to gather his equipment and take it with him, and the attorneys would have to gather their files, etc. The rules I do make on questions of law in your presence are not evidence, and you are to disregard them. After all the evidence is in, and both the state and the defendant have rested their cases, the court will prepare and submit to you a written charge instructing you on the law in this case. We will then hear oral arguments from the attorneys. The attorneys have the right to make a summation of the evidence and to make reasonable deductions from the evidence. Since the state has the burden of proof, it has the right to open and close the summation or argument. Until you retire to deliberate, do not discuss this case amongst yourselves, and under no circumstances should you permit anyone to discuss the case with you. Do not attempt to learn from any source outside of the courtroom anything about the facts of this case, nor attempt any independent investigation on your own. Don't visit the scene involved in the facts of the case. Don't read any reports in the newspaper or on social media or watch TV reports about the case. Do not make up your mind about this case until all the evidence is in and you have been instructed on the law. Don't take notes during the progress of the trial. Don't visit other courts during a break if a trial or other proceeding is in progress. The badges that you have, you will be allowed to take those badges home with you. Please wear those badges when you come back to the courthouse because those badges identify you as a juror in this case. Now, ladies and gentlemen of the panel, those of you who were not selected to serve as a juror in this case, first of all, I'd like to thank you for your time and attention, for being here this afternoon. As you're aware, there are only a limited number of individuals who can serve as jurors in any particular case. I know that you may be disappointed, but be not disappointed because your presence here helped this court to move cases. And what I mean by that is, before you even came to this court at 1:30, we had cases on our jury trial docket. And even before today, months ago, defendants who was charged with a crime was given an offer by the state to settle the case. And some people settled it, and some people decided to exercise their constitutional right to have a trial by jury. And now some individuals decided that they wanted to have a trial because they believe one or two things may happen. Some people actually believe that a jury will not show up, or some people believe that witnesses will not show up. But on days like today, when you show up, sometimes it's not uncommon for some individuals to have a change of heart. What that basically means is they realize that a jury is going to show up, and they decide, you know what, the offer that the state made me a few months ago, it looks pretty good right now. So you've helped us to move cases, and we like to thank you for your time and your attention. Now, your jury service, it has concluded, but I like to say this: anytime that you're in the area of County Court at Law Number 2, you can come and have a seat in your courtroom. I know that when you came here this afternoon, you probably looked over the top of the door and you said, "Oh, this is County Court at Law Number 2. I'm in the right place because this is Judge Terrence Holmes' court." No, this is not my court. I'm only a humble public servant serving the citizens of Jefferson County. You are the citizens of Jefferson County, so this is your courtroom. So anytime that you feel free, you can come and have a seat in that area that you're sitting in. We call it the peanut gallery. But it doesn't mean you could bring peanuts in here and eat, because this is not the Texas Roadhouse. But you can have a seat in your courtroom, and I'm sure you'll find it to be very interesting. Now, our bailiff have some letters for you. She's going to give each and every one of you a letter before you leave. And also before you leave, I usually give all the members of the jury a handshake. We still have COVID in our community. However, I like to give what I call an air handshake. So on behalf of citizens of Jefferson County and the staff here in County Court at Law Number 2, thank you for coming to County Court at Law Number 2. And each and every one of you have a blessed day. Mr. Hubel, I think there's some letters on the end of that table. You can hand it to the bailiff if she's outside that courtroom. As you go out the courtroom, she's going to hand you letters. Okay, so you're free to go, and y'all have a blessed day. Okay. Yeah, the bailiff is going to be on that side. Okay, now, ladies and gentlemen, jury, it's my understanding the state is going to start testimony. In this case, starting at 1:30 on tomorrow. Is that correct, state?
Yes, Your Honor.
Okay, so ladies and gentlemen of the panel, you'll be excused to 1:30, and when you come back to court on tomorrow at 1:30, please have a seat outside the courtroom, and then when we are ready for you, the bailiff will come out to get you. So at this time, you are excused. Everyone, please stand as the jury exits the courtroom.
So I did.
You may, oh, okay. Miss O'Neill, you and your attorney are free to go.
Thank you.
God bless that. And state, with Ms. Stratton, you are asking to reopen testimony,
Really, Your Honor.
Briefly on.
okay? Ms. Provo and Mr. Stratton? Okay, so the state is reopening testimony on the motion to revoke Mr. Stratton's bond. Ms. Nixon, you may go forward.
Okay. State calls,
Well, he was already,
Okay,
if
just
it's
making sure.
reopened, he already been
reopen,
sworn in.
okay, okay, sure. Mr. Stratton, are you wearing a global positioning monitoring system?
Yes, sir. I mean, no, ma'am, because when I went there to go make, tell them I couldn't make a payment, they cut it off of my leg and told me I couldn't get it back on my leg without making a payment. And I was in Unity at that time, so I couldn't have a job. So the payment built up. The charger broke at Unity. I tried to go get another charger. Whenever I brought the device there to get the other charger, they just cut it off my leg. I asked them, I need this on me. They told me that I had to pay them like $600 that I didn't have at that time because I was that behind being in Unity. So I was trying to get better and not understanding.
Okay, so,
Went back to the place to try to get a brand new charger so I could keep using it.
okay, state? Anything else?
Just that he's violating now two bond conditions, number 3 and what's listed as 7, but I believe it should be 6.
Well, it's 7.
7,
It's as it
okay.
is.
So, and bond numbers and
Okay,
bond condition number 7.
hold on, what up? You have any questions of your client?
Yes, ma'am. If, Trevor, if you would have known, would you, that you needed to have a monitor, would you have seek one?
I would have tried to go get one, but they told me that I had to pay them like $600 something before I could ever get one again. I don't have that money right now. I don't even have a vehicle or a job. Like I said, I just got out of treatment not too long ago. So it's kind of,
Ms. Pro?
and I've already been to court 2 other times without the monitor on. And nobody has said nothing.
Have you informed your bond?
I've
Your
already-
bondsman?
I've told the bondsman. They said they didn't have to deal with it. I told them the same thing I'm telling y'all. They cut it off me. I can't pay them. Said I don't want mine to be revoked, and they said, try to talk to the judge, because if you can somehow beat that case, that I can get a letter from you and I didn't have to pay it or something like that.
Okay, Ms. Pro?
I have no question.
Say?
So it's your testimony that you've been to court twice without the GPS monitor on?
Yes, I cannot afford it right now.
And at any point, did you inform
Yeah, for my bonds as soon as.
Did
they
you
took it
inform
off.
your lawyer?
I don't know, I had to. I thought I just had to inform my bondsman. I was in control of everything.
Didn't your bondsman tell you to talk to the judge?
I honestly can't remember that.
That's what you just said. You told him that you needed to talk to the judge.
No,
Sure.
no, I'm talking about not the bonds people, the ankle monitor people. Told me I have to go talk to the judge. See, you're getting mixed up. I didn't say.
But your
The
bank
ankle
mon
monitor
people, did you
not the
edit?
bonds people, after the ankle monitor people cut it off, I called the bonds people and told them that they cut it off and everything. Because I was freaking out about it.
So regardless of who told you to do it, are you saying that you never talked to the judge about your on-foot monitor being removed?
I didn't remove it. They cut it off my foot.
About it being removed, sir? You never spoke to your lawyer or informed the judge or this court that you're no longer wearing the GPS monitor?
I thought it was a bond thing.
The bond
So
was,
that's what I did, was call my bondsman.
Anybody else?
Your Honor, I just want to reiterate, for the safety of the community and for the complaining witnesses in the case, that the state moves to revoke the bond, the defendant's bond on violation of condition number 3 and number 7.
Okay. Okay, that motion will be granted. And at this time, Mr.
3 and 7, sir.
Mr. Stratford, Mr. Stratton will be taken into custody.
What is
He's
3 and
gone,
7, sir?
at large without proper.
7. One is three.
7 is GPS, 3 is contact.
I've not been in contact with him.
Okay, he's free to go. He's free to follow the bill.
Give my dad my phone.
I'll give it to you, it's, what's going there.
Right.
Everything you wanna get, well, you can give it to me. You sunglasses too? You don't know, you